Howdy, welcome to another episode of Duck the Law. Now, one of the most ubiquitous things we see on legal TV is the Miranda warning, and everything you think you know about it is wrong. Let's talk about it. The way the Miranda warning has been shown on TV has done the public a huge disservice because they almost always get it wrong. So let's go over some of the most common misconceptions about Miranda. Now, the first misconception is that it's called Miranda rights. It's a Miranda warning. Miranda doesn't give you any extra rights before or after they're read. It's a warning, a reminder that you have these rights. And it's a warning and a reminder that you should probably shut up and not talk to the cops. Now, you have always had these rights. You have them from the day you are born. And you already know these rights. You have it memorized. You don't need some dumb cop to remind you that you have the right to remain silent. So don't expect it. The Miranda warnings come from a case called Ernesto Miranda versus Arizona. I'll leave a link in the description for you if you're interested in reading it, but it's not necessary. I'm going to go over the basic rules in this video. So misconception number 2. The cops are required to read me my rights when I'm arrested. That's false. In the vast majority of cases, you'll never have your rights read to you when you're arrested. And let's be real, you already know your rights. You can recite them without the help of a cop. You don't need a cop to remind you of what your rights are. So when are they supposed to read you your rights? They're only supposed to read you your rights prior to a custodial interrogation. So what does that mean? It means you're in their custody and they're about to interrogate you. Now, in most cases, they won't read you your rights. Why not? Because it's unnecessary. Because if you are already under arrest, that means they have some evidence, they have some probable cause to arrest you. So they don't need anything else. They don't need to ask you any other questions. They don't need to investigate further. You're already under arrest. They have what they need, and there's no need to read your rights. Misconception number 3 is I can get the case against me dropped because the cops didn't read me my rights. That is false. I used to get this call all the time. Guys would call and be like, "Oh, I did this heinous crime, but they didn't read me my rights, so I can get my case dropped, right?" No, doesn't work that way. Keep in mind that anything you tell the cop is probably being recorded. The inside of their police car is being recorded. The booking process is being recorded. The holding tank and the jail cells are being recorded. The phones that you use in the jail are being recorded. So any statement you make after you're arrested, almost all of them are recorded. And anything you say will be used against you in court if they can. Even if they're not recording, a cop's recollection, their memory of what you said, is admissible in court. Even if they misunderstood or misinterpreted or misstated what you actually said. And that's why it's recommended that suspects or defendants never make any statements to the police. You're not going to talk yourself out of the arrest. The cop's going to do whatever they want, and anything you say can only be used against you. It can never be used to help you. Another misconception about Miranda is if they don't read you your rights, that they can't use your statements in court. And that's just not true. Any voluntary statement you make can be used against you in court. And this includes statements made to undercover cops or informants in the jail. So it's very important that you never speak about what you're being accused of when you're locked up. The only person you should be having that conversation with is your lawyer. Now, can you sue the cops if they don't read your rights? No, that's not a recognized cause of action. If they don't read you your rights, your only remedy is that they cannot use those statements that you gave during a custodial interrogation. It's best not to say anything without a lawyer because your actions can be implied as consenting to giving those statements. So there's a lot to unpack here, and most of it's for attorneys to deal with. But what do you need to know in the moment? Let's talk about that. Let's separate this into two parts: your right to remain silent and your right to an attorney. Okay, so everybody knows that you have the right to remain silent, and anything you say can be used against you in court. But here's the other part to that they don't tell you, is that anything you say that could help you cannot be used to help you in court. So anything you tell a cop can only be used against you, not for you. And this is true whether you're detained or not detained, or arrested or not under arrest, or in custody or not in custody. This is true at all times. If you are a suspect or a defendant, it's never in your best interest to speak to the police without an attorney. So exactly what are you supposed to say when the cop is in your face and threatening you with arrest if you don't answer questions? Well, that's easy. You say, "I don't answer questions." And that should be the answer to every question. Let's see how it's done.
I don't answer questions. I don't answer questions.
You don't answer questions?
That's correct.
What's the reason for that?
I don't answer questions.
Hello.
How are you doing?
Good. Do you know this lady back there in the accident, or?
I don't answer questions.
Okay. Well, have a nice day, sir.
All right, thank you.
Can I help you? Are you Kenneth Suter?
I don't answer questions. Can I help you?
I was looking for a Kenneth Suter.
I don't answer questions.
You lost?
I don't answer questions.
Pronounce your last name for me.
I don't answer questions.
I'm going to need you to pronounce your last name.
I don't answer questions. It's there on the license.
Who's the gentleman you were just standing here?
I don't answer questions.
Is there a reason why?
I don't answer questions.
Do you have a nice day?
You too.
Can you give me your phone number?
I don't answer questions.
Okay, is there anybody here that can answer questions?
Don't answer questions.
I'm not sure how to respond to that, sir.
Sorry. Have a nice evening.
Okay, I'll be back.
Okay, the second part to Miranda deals with lawyers. It says that you have the right to have a lawyer present during questioning, and if you cannot afford one, the court will appoint one for you. So let's unpack what that actually means. In order for you to properly request a lawyer under the law, your request must be unambiguous. So the words you have to use is, "I want a lawyer." That can't be confused with anything else. I want a lawyer. So here's some examples of what not to say. "I think I should talk to a lawyer." That's a statement. "I think you should give me a lawyer." That's still a statement. You're not requesting a lawyer. "Maybe I should have a lawyer." That's a question. "I should probably have a lawyer present here." Yeah, you probably should, but you still haven't unambiguously requested a lawyer. "Why don't I have a lawyer here?" That's a question. The statement that's unambiguous that gets you a lawyer is, "I want a lawyer." Okay, so the cops should stop asking you questions after you request a lawyer. But if they don't stop asking you questions, and if you continue to answer the questions and engage with them, the court could imply that you implicitly revoked your request to have a lawyer present. So that's why it's very important to say, "I want a lawyer," and then be quiet. Or if they keep asking you questions, you can just respond with,
I don't answer questions.
okay, so you requested a lawyer. Do they immediately give you one? No. Usually you'll have to wait until your arraignment, where the judge will then ask you if you want a public defender assigned to you. Now, usually you have to meet some financial requirements before they'll give you a public defender. But even when they assign you your public defender, it could still take days before they talk to you. So let's go over Miranda again. You have the right to have an attorney present when you're being questioned. And if you cannot afford one, the court will assign one for you. Now, those statements are true, but it doesn't happen immediately. It takes days usually. So don't expect a lawyer when you ask for one, but stay strong until it happens, because you should always have a lawyer present. Okay, so let's talk about what we learned today. If you are arrested, they probably won't read you your rights, and they don't have to, because you already know them. You have the rights outlined in Miranda from the day you're born, and you never need some swine to remind you of what they are. You always have the right to remain silent, because anything you say can be used against you in court, and nothing you say can be used to help you in court. I don't answer questions is always a valid response. You have the right to speak to an attorney, but you don't have the right to an immediate attorney. It's usually going to take a few days. As always, nothing I say in this video is meant to give you legal advice. This is just a brief introduction and explanation of what the law is. And any hypotheticals I use is just to illustrate that point. The law is very complex, and you should always seek the advice of a licensed attorney in your jurisdiction anytime you need to apply real-life facts to the law. If you enjoyed this video, please hit the like button, hit the subscribe button so you don't miss another video. I also respond to all the comments, so if you have any comments, questions, suggestions, you have a video you want to see, go ahead and leave it down in the comments. Until next time, duck the police and duck the law.